right. Hi, everyone. Welcome back to this channel and to the Civil Procedure Lecture Series. Today, we will be focusing on pleadings, what they are, how to draft them, and what rules of civil procedure apply to them. This is going to be the second of two main pleading videos. If you'd like to check out the first one on general rules of pleading and statements of claim, please go and do so. Today, we'll be focusing on statements of defense. So let's get started. As you remember from the last video, pleadings are the first step on this long and winding road of civil justice. They are the process by which the parties can put their best foot forward initially, and they really define the scope of the dispute and who the parties are. So it's this documentary conversation between the plaintiff who is suing and the defendant who is defending themselves against the suit. We know that they serve both to put the other side on notice about what is being alleged, and it's also to define the scope of litigation moving forward. They're a great piece of narrative advocacy as far as convincing the other side and the decision maker of your story, and this will really kickstart all the steps to follow in a conventional civil action. So today we're going to start with a case, and this case is called Whiten and Pilot Insurance Co., and it's a 2002 case from the Supreme Court of Canada. Now, this is a big case for contracts, but it's also a case that speaks to pleadings, what needs to be in them and what really doesn't belong in them. So this is Keith and Daphne Whiten, and they sued the Pilot Insurance Company. So their house essentially burned down, and with it many of their antiques perished, their cats, and when they went to realize on the insurance policy, the insurance company engaged in bad faith. So the insurance company claimed that the Whitens had actually intentionally set their own house on fire, meaning that they were accusing them of arson. And for the purposes of insurance policies, you can't claim insurance for arson, right? You can't burn your own property down and then go ahead and claim the money for it. So the insurance company goes on accusing them of arson after they just lost so much. And the court really found this conduct by the insurance company to be so egregious that it merited an award of punitive damages, right? Remember punitive damages from last class? It's not necessarily to compensate you for what you've lost, but it's to give you extra money for such bad behavior from the other side. Daphne, the wife, she purchased this policy for peace of mind and protection in an emergency. And when the emergency arose, she was left in the dark, right? This insurance company totally did a 180 on her, started accusing her of arson, and they didn't deliver what they were supposed to, what they promised to do in situations like these. But there's a few things that are important about this case. So the first thing is the amount that the jury awarded to the Whitens. So what was the amount that the jury awarded them at trial? Remember, there are general and aggravated damages, which are compensatory and meant to put the party in a position they would have been in had they not suffered a wrong. There's also the punitive damages, which we just spoke about, which are above and beyond the compensation, and they're really meant to soothe this egregious type of behavior. So the Whitens had to spend $320,000 in lawyer fees to get this case to trial. And they got $345,000 in return in an award. So ultimately, in winning the case, they were awarded lots of types of damages, including punitive, and the total amount was $1.345 million. Now, although that seems like a lot, as we spoke about last week, this was very much a Pyrrhic victory. Although the Whitens eventually won, they had to expend so much money to get there, so much time, so much resource, that really in the end, the award, it was great, but it came after such long turmoil. And this was partly why the jury chose to award them that large compensation, because it was clear from the beginning that the defendant's conduct was designed to force the plaintiff into an unfair lowball settlement. So by the time the case came to the Supreme Court, Pilot Insurance had given up the arson piece, and now they were focused on the pleadings, the way the Whitens designed their original statement of claim. According to Pilot, the Whitens didn't properly lay out the material facts to plead punitive damages. Therefore, they were claiming it was an improper pleading with respect to this. So they're saying the Whitens just told their story, but they didn't use those checkpoints. They didn't specify how they could ground their claim for punitive damages beyond the regular compensatory damages. So according to Pilot, they're saying the Whitens breached Rule 25.061 of the Rules of Civil Procedure, which is focused on material facts. Pilot is saying, yes, you mentioned punitive damages in your claim, but you didn't give the material facts to ground those extra awards. Remember, when you're drafting a statement of claim, to get to your conclusion, you need to lay out the facts specifically as to why you think you deserve that award. And the case that Pilot relied on is Vorvis to get this idea of special material facts for grounding a claim in punitive damages. They're saying punitive damages are extra, so you need to be extra specific. And this argument doesn't really get blown out of the water immediately. The court says, yes, pleadings must specify what it seeks as a matter of fairness. And the facts to justify punitive damages should be there. They should be stated with some particularity. You have to give the other side notice as to what you're suing for, or else the process would be quite unfair, right? However, the court says just because the Whitens are missing some material facts, or that the statement of claim is somewhat deficient, it doesn't mean it's not good enough. And if Pilot was really so concerned, they could have moved for something called particulars. So the idea is, if they were concerned, they could have asked the court and asked the other side to deliver particulars, meaning that they could have asked the plaintiff for further details about what they're suing for, rather than waiting all the way to trial to identify deficiencies in the pleading. So recall, civil actions are long and winding roads, but throughout the rules of civil procedure really want to encourage this early settlement. We want to try to avoid spending so much time and money and resource and energy to get to the end. And so the court is saying, if you really had a problem with this, why didn't you catch it so many steps before the trial? Why did you wait so long? And because you waited so long, we shouldn't really have to entertain anything of what you're saying. The rule is, if there's a deficiency, you should correct it as early as possible without dragging it all the way to trial, especially if it's something like a typo or a fixable error. So the Supreme Court gives us this important statement starting at paragraph 87, that one of the purposes of a statement of claim is to alert the defendant of the case to be met. If at the end of the day the defendant is surprised by an award against it that is a multiple of what it thought that amount would be an issue. If that's the case, there's an obvious unfairness. Whether or not the defendant has in fact been taken by surprise by a weak or defective pleading will have to be decided in the circumstances of a particular case. So this is a basic matter of procedural fairness. But it also represents this theme in civil procedure that we talked about last time, that there should be no surprises in any civil litigation. On TV, courtroom surprises are a staple, right? They just pull something out of left field, everybody gasps, and it's this big thing, and you know you've slam dunked the case. But in the real world, that actually isn't allowed. And the justice system goes to great lengths to actually prevent surprises like this because they're really, really unfair. You want everything out on the table. This is at every stage, including the stage following pleadings like discovery, where the parties have to disclose all the evidence that they have to support their claims. But when you get to discovery, you can only ask questions about the issues identified in your pleadings. So your pleadings need to be specific enough as to what you're suing for. You can't surprise the other side. And remember, the rules are conducive to allowing you to modify or amend your pleading if you've left something out that you think you want to add in. But you need to lay the groundwork from the beginning. So pleadings are often expansive and long, and there's no page limit on them because the law doesn't want to constrain a party's ability to identify all the issues and the claims that they want to present. So in this rule about noting everything and not surprising the other side, there's also something there about encouraging settlement, which is another theme we're going to come across a lot in the rules of civil procedure. Why is it that requiring things to be specifically pleaded and backed up by material facts make it more likely that the parties will settle? Why do we need to be specific about our damages? Again, if you'll recall, this is because it allows parties to assess the risk of litigation versus settlement. If everything is expansively pleaded and parties know exactly what they're risking, they can make better settlement offers and they can decide if it's actually worth settling early or going all the way to trial. If we allowed surprises, for example, and we concealed our aces, let's say, to ensure that we didn't let the other side know what we were going to argue and we didn't want them to have enough time to find a defense or make their own arguments, then the other side wouldn't really make settlements that encompassed all the things, all the extra things that we wanted in our claim, because they wouldn't know that you wanted more. So it does really backfire in a way. You want to be clear about what you want because that gives the other side room to A, decide if it's worth strapping on their boots and hauling through to litigation. And it also lets them know specifically what is it that they can negotiate with you and settle with you based on what you truly are looking for. All right. So next we have Rule 49.061, Disclosure of Offer to Court. No statement of the fact that an offer to settle has been made shall be contained in any pleading. So this seems kind of counterintuitive with what we just said, right? We just said we want to encourage settlement through the rules. We want to lay everything out on the table. But then this rule is saying that the pleadings, the documents, actually can't talk about settlement. So if you've made an offer or received an offer, you can't go ahead and write that in your pleading and say, actually, they made me this offer and then I denied it. But we want everything to be out on the table, so why might this be? Well, this is for a couple of reasons. First, a settlement offer can be seen as indicating an admission of liability, so it could bias the decision maker in not taking a claim seriously. So think about it. If your claim is 10 million, but the other party says you're willing to accept only 1 million in settlement, that's what you've negotiated. Why would the decision maker take it seriously that you're actually looking for 10 mil if you're just so willing to accept much, much less? So it could bias the decision maker in admitting this kind of liability, admitting that you've had this discussion and that the other party is actually willing to settle for much less. Because if you end up going to court and you don't end up settling, it might backfire against you. Furthermore, if the other side can disclose your settlement offer in the pleading, there is a strong incentive not to make it because you don't want it to come around and bite you. The rules want people to feel free to make settlement offers without ruining what they're claiming if their settlement falls through. So if you end up not agreeing and moving forward to trial, you don't want that settlement step to undermine what you're truly asking for in the end. You don't want it to undermine your ultimate claim or the authority of your legal position. So that's why you're not allowed to disclose an offer of settlement to the court. You want to keep this between the parties because if it falls through, you don't want it to come back and hurt either party in any way. If you decide not to agree on a settlement, you've both decided, okay, we tried to negotiate, it didn't work, Now we're going for the full course of what we've asked. All right, so last time we looked at our statement of claim, and as you'll recall, it was the case of a plaintiff, Adam, who was terminated from his employment with Eva Evergreen. Adam is this very seasoned, specialized accountant, and he's claiming that the company made him promises to take a job with them with respect to salary, flexibility, the workload, and they did this to lure him into accepting a job offer. But when he did quit his job, where he was at the height of his career, when he quit his job and ended up working with Eva Evergreen, none of those promises and representations were realized or delivered. He's also claiming that they discriminated against him on the basis of religion. As a religious man, one of the terms he said he agreed to upon hiring was that he could take as many days off as he needed to observe religious holidays. But then he's claiming that they went back on that, and when he asked for those days, they made remarks about it. They didn't want to give him those days. So apart from an ultimate breach of a term of their contract, there was an underlying discrimination to it. So overall, he's claiming that he was exploited for his expertise, and when he tried to get what he was promised, they fired him under the guise of just cause, claiming he was incompetent in his work. So lots of things going on here. Today we're going to look at the other side of the dispute. So we're going to really delve into the company's version of the story. So the company has a different story, right? The company is not going to say, yeah, we were discriminatory, we lied to you because we wanted to poach you. They're not going to say that, right? Because they don't want to be held liable, and that may not even be true. Every story has two sides. So what is the company saying? So the first thing is that the company establishes who they are. You'll notice in the statement of claim, the plaintiff is really shining himself in the best light because he wants the reader to empathize with him. Remember, pleadings are narrative advocacy, so you want to have that emotional connection come through. But not only was the plaintiff putting himself in a great light, he was kind of casting a bad light on the defendant because he doesn't really want to spend time singing their praises. This is about him. This is his time to tell his story. So the focus is on him. In a statement of defense, the defendant's going to want to take this opportunity to really fledge out their account of the events. And part of that means that they want to show who they really are to the decision maker, not who the plaintiff has painted them to be. It's like their 30-second elevator pitch. All the plaintiff said was that they were a company that sells home appliances. That doesn't really seem enticing. When you get to the defendant's side, the pleading for the defendant, the language is really, really different. And this is what we see. So the company was founded over 45 years ago, prides itself on quality goods and services, a large, bustling business, works with its clients to get them the best products and services without the hit to their wallet. Their initiative to better services and encouraging a cleaner earth. So the language here is really different. They're painting a different picture, right? They're saying they're providing tax breaks. They're really trying to show themselves in the best light about how this company is really doing the most. Like, this is a good company. This is a good guy in the story. So then it gets to the meat of it. This company says, given these complex services that they offer, they require a seasoned accountant and economic advisor to keep track of their financials, arrange the best deals for the company and the clients, and engage with the clients during a busy tax season. So this is what their version of the story is going to be. They're going to claim that the plaintiff wasn't what they needed. Specifically, they're going to say he wasn't doing the work, right? He didn't cut it. He was taking time off willy-nilly without letting them know in advance, and he failed to keep up with his deadlines despite accommodations. Okay, so before we get into the rules of civil procedure, The first thing you'll want to know is that statements of defense are much shorter than statements of claim. That is because in statements of claim, the onus, meaning the duty, is on the plaintiff, the person suing, to establish all the facts and claims, since they're the party starting the lawsuit. So since they're starting it and they're claiming XYZ, they need to set out exactly what it is they're suing for, and so that tends to come with more detail of the story of how they were wronged. So let's jump into the rules of civil procedure that apply to statements of defense. So first, the rule we're going to be looking at is Rule 25.07. Rules of pleading applicable only to defendants. This is only for statements of defense. And this rule talks about the different types of text that can appear in a statement of defense that a defendant can do to respond to a plaintiff. So there's 4 specific kinds of text, and these are admissions, denials, lack of knowledge statements, and affirmative defenses. And we're going to go through them one by one to see how they play out in our statement of defense. So at the outset of our statement of defense, you recall every statement of claim and defense has kind of this boilerplate first page, second page thing going on. For our statement of defense, we have this language here. It has a summary of which claims from the statement of claim are admitted, denied, and which of them the defendant has no knowledge about. So a handy website, again, to get the template for these boilerplate pages for statements of claim and defenses is ontariocourtforms.ca if you are litigating in Ontario. The statement of defense is going to be under the Rules of Civil Procedure tab, Form 18A, and this gives you the template for these 4 boilerplate texts. So this is going to be at the front of every statement of defense. It's just going to be a little bit varied depending on the paragraphs agreed upon and disagreed upon. But the defendant is going to have to lay out in a summary which they admit to, which they deny, which they have no knowledge of, and then they're going to tell their account of the story. So let's start with the first one, which is admissions. Rule 25.071. A party shall admit every allegation of fact in the opposite party's pleading that the party does not dispute. So on the first page of the statement of defense, we see that the defendants admit to paragraphs 2, 6, and 7 of the statement of claim. And if we go back to last lecture, this is the statement of claim, paragraphs 6 and 7. The defendant is admitting to these paragraphs. So if we look at these paragraphs, they're explaining the plaintiff's credentials, his specialization, and who they are. So effectively, by admitting to these paragraphs, the defendant is saying, I'm not disputing any of these credentials. I'm not disputing any of these facts surrounding the plaintiff's specialization, so that they don't need to come up again as a point of contention. I'm not going to bring this up later and argue that none of this is true. I agree that it's true. We can leave it behind and move past it. They're admitting this because they have to do so by Rule 25.071. If it's admitted, there's no longer room for contest, and the plaintiff doesn't have to waste time or energy at the next stages trying to prove that they're specialized or prove that they have this bachelor. So it's interesting to compare this with a criminal proceeding. If you're charged with XYZ and you agree you did X and it's clear you did X, you're still not required to admit that you've done it, unlike in the civil context, because in the criminal spectrum, you are entitled to a presumption of innocence. And you have to put the Crown, the state, to the test, as it is their onus, their duty, to prove every element of the crime beyond a reasonable doubt. But this isn't the same in the civil case. In the civil case, you're required to admit everything that you agree with. So what's the difference? Why don't we have the same expectations of defendants in both cases? The main reason has to do with power and risk. Everything about criminal procedure is informed by a perpetual power imbalance between a powerful crown and an accused who lacks that. In the civil context, especially in the corporate context, the parties will likely be more on the same playing field. Your liberty is also not at stake in the civil realm, so the stakes are very different. And civil procedure really wants to narrow things down and identify the issues to make things a little bit faster. So requiring defendants to admit what they don't dispute allows that expediency. And it's also really good practice because it demonstrates to the decision maker, the finder of fact, and to the other side that you've taken the time to carefully read through their statement of claim and you've really thought closely about what you can and cannot agree with, paragraph by paragraph, maybe even sentence by sentence. Another thing to note is that if you do only agree with some part of a paragraph, but not the whole thing, you can indicate that. You don't have to take it really paragraph by paragraph. So the next thing we have are denials. So the defendant first denies the relief sought in paragraph 1. As you'll recall, the plaintiff asked for various cost awards, as well as a declaration that they had been discriminated against on the basis of their religion. So the defendant is really saying, no, we deny that we need to do all this. We deny that any of this is true. They also deny the paragraphs in the statement of claim that have to do with what the plaintiff claims happened. So they're going to deny the representations and promises that the plaintiff is alleging were made. They're going to deny that the promises weren't kept. They're going to deny that they persuaded the plaintiff in any negligent way or that they used him for his expertise with malicious intent. They're going to deny discrimination. They're going to deny that the salary wasn't what they said it would be, and so on and so forth, right? They're going to deny all the things the plaintiff is using to make his case that the defendant doesn't agree with. Remember, this is the defendant's version of events now. They're saying, well, you know what, hold on, something else happened here, and I'm not going to agree with what you're saying because it's not true. Their story is that the plaintiff wasn't working up to par, that they made different arrangements, which they honored, and that the plaintiff purposely didn't meet the deadlines. Also, if we go to paragraph 23 of the statement of defense, this is the defendant's pleading now, we're going to see a denial of damages. So the company is denying that the plaintiff suffered any damages, and they're putting the task to him to prove that he did. We have here paragraph 24 in the alternative. If you'll recall from last time when we used those words, we're likely referring to an inconsistent pleading. So what this means is that we're saying X, but it might actually be Y. So we're going to put both in there to cover all of our bases. So this is what they're doing with their damages here. They're denying point blank that the plaintiff suffered any damages. However, if that's not the case, in the alternative, that the plaintiff can actually claim for damages, they're going to claim that those damages are excessive, remote, and not recoverable. And if he did suffer damages, in this alternative reality, if that's the case, he failed to mitigate those damages, so he shouldn't be awarded a cost award. So what does it mean to fail to mitigate? Failure to mitigate is a term you will very often see in termination suits and employment matters. And basically what that means is that you failed to cushion the impact or lessen the harm in a wrongful dismissal lawsuit. So if you were terminated from your position, you'd mitigate your damages. You'd want to cushion that blow by looking for another job to lessen how much money you would have actually lost, to lessen the impact of termination on your life. So this is part of employment law. even if you've been fired wrongly and you're entitled to compensation from the defendant, the law still expects you to go out and find a new job in the meantime to really cushion that blow. And the damages you're going to be awarded are going to be only for what you've truly lost. If you don't seek a new job, your damages are likely going to be reduced because you didn't take that time to cushion your damages. You're just kind of trying to milk it for as much as you can. And the law doesn't really see that in the best light. If you deserve X amount of damages, you'll likely be awarded those damages. But if in failing to look for a new job, you've now accrued XY damages, the law doesn't really know if it should award you those extra Y damages that you've kind of caused on yourself. Because why should a defendant be liable for something he didn't cause additionally? So anyway, the defendant has to specify what they deny at the outset and then get into more detail in the body of the text. So recall in the first page, he's going to deny, and then later on, he's going to specify what he denies. Now, if we continue down these paragraphs here, paragraph 26, the company is saying that even if he did suffer damages and they're not rewarded and they're not remote, and he did mitigate his damages, we are not on the hook for punitive damages. So we might be on the hook for compensatory, but we're not on the hook for this extra award for punitive or aggravated damages. So what you'll see happening here is that they're denying every level of what is being put against them. And that's what you want to do. You want to deny every level put against you at the various stages to stop the bleeding from getting worse. So first they're saying, we're denying full stop that plaintiff suffered any damages. But in the alternative, if they did suffer damages, they're too remote. You can't recover. But if you can recover, they fail to mitigate, so they shouldn't be allowed to recover. But if they didn't fail to mitigate and they are allowed to recover, and we are on the hook for general damages, we definitely shouldn't be on the hook for aggravated or punitive damages. So you'll see, as the levels of damages escalate, the defendant is really trying to stop the bleeding at every stage. Now, whatever you're not denying is usually taken to be as an admission. So you might want to make sure you add a catch-all statement at the beginning of your statement of defense, right? If you have your first page here, let's say you add a statement here at the bottom, a catch-all statement that is saying something like, except as explicitly admitted, everything that isn't admitted is considered to be a denial. All right, so next we have lack of knowledge statements. A lack of knowledge statement basically means that you're saying there's no reason to deny something because you don't know it to be false, but you also don't know it to be true, so you can't really admit it. You simply just don't know, and you're not going to be contesting it, you're not going to be arguing it or getting evidence to prove the contrary. You're just kind of going to let it be. But if the plaintiff wants to use it to make their damages higher, they need to prove it to you. So an example of something the plaintiff claims that the defendant might plead, lack of knowledge, is paragraph 10. So this is paragraph 10 of the statement of claim on the plaintiff's side. It says that the plaintiff is an avidly strict religious man and that he must take 2 to 10 days off a month to observe religious holidays, and he's been doing so for the last 20 years. The defendant really has no reason to believe this is false, but they also have no reason to know if it's true. So who really knows if he's an avidly religious man? Who really knows what he's been doing for the last 20 years? But because they're not really in a position to admit it's false or true, they're just going to plead lack of knowledge. They're going to plead this idea that I don't really know, but if you want to rely on this to increase their damages, which they likely will because they're going to use this as a discrimination, as a kind of boost to their discrimination claim, or to boost the fact that the promise of flexibility wasn't kept. If they want to use this fact, the plaintiff will need to lead evidence to that effect. So that's why it's different from an admission. If the defendant had admitted it, the plaintiff wouldn't need to prove it. If the defendant denied it, they'd be putting the plaintiff on notice that they're going to bring up evidence to the contrary. However, if you plead lack of knowledge, which is kind of this in between, you're signaling you won't be contesting it, so you're not going to be bringing evidence against it, against this particular assertion. However, if the other side wants to use it, they need to be prepared to prove it with their evidence. Many statements of defense won't even have lack of knowledge statements. You might just have admissions or denials. You might not be in a position of ambivalence like this. But it's good practice to have it if it's there, because it signals, again, that you've read the statements carefully. It builds the credibility that you're not unnecessarily lengthening the process. You've tried your best to keep it short. You've tried your best to concede to what you can. And that will all play into costs later on in the game. If you are a good player in this process, the cost against you if you lose will be reduced. So at the end of litigation, the court's going to offer extra payment and typically compensate the successful party extra for the fees they had to pay to get to that success, right? And they're going to punish parties who made that success more difficult, who participated in bad behavior to unnecessarily lengthen the litigation or put the other side through unnecessary expense and evidence gathering. All right, so lastly, we have affirmative defenses. Rule 25.074. In a defense, the party shall plead any matter on which the party intends to rely to defeat the claim of the opposite party, and which, if not specifically pleaded, might take the opposite party by surprise or raise an issue that has not been raised in the opposite party's pleading. Okay, so this is a lot. Let's break it down. So affirmative defenses are new material facts that make the defendant's position the legally correct one. So the plaintiff is saying he was fired because he was discriminated against, but the defendant's position is not that he was fired for discrimination. They're going to have a different version of events. So this will be their affirmative defense. So they're saying, we were keen to hire him, and yes, we fired him, but that's because he didn't do the work properly. He didn't put the hours in, the quality was low, and he wasn't up to snuff. This comes out here when they give their own details of the story. This isn't an admission. It isn't, right, they're not admitting to what the plaintiff said. It isn't a denial. They're not denying anything the plaintiff said. And it isn't really a lack of knowledge because they're not alleging that they agree or disagree or don't agree or disagree with anything the plaintiff said. Rather, this is a new story for why the defendant's position that they shouldn't have to pay him money is the legally correct one. So an affirmative action isn't a direct reaction to anything in the statement of claim. Rather, it's a different version of events that hasn't been brought up yet. It's a different version of the facts. If you intend to prove a version of the facts different from what was pleaded in the statement of claim, this rule says that a denial of the other side's version isn't enough. You can't just say, I deny that discrimination happens. You need to actually deny, and then you need to state your own version of the facts. So rather, you need to say, discrimination didn't happen, but what actually did happen was X, Y, Z. And part of this is because of this overarching theme in civil litigation and civil procedure that we don't want any surprises. You don't want the plaintiff to be surprised by the fact that you're going to run with this whole new story, in this case, incompetence. Once this incompetent story is raised, the plaintiff who was fired becomes kind of, in a sense, the defendant. So they need to have their own ability to build their case and defend themselves against these new allegations. So what's the defendant's affirmative defense? What's their version of the story? Recall in the statement of claim, the plaintiff said the company sought him out specifically. They offered him a great salary, flexibility, seniority, and that they never delivered on any of those things. They didn't give him the time off for religious holidays, they were discriminatory, all this stuff, right? And the defense is saying, well, actually, that's not true. We deny any of that happened, as we've seen before. They denied all of those claims, and now they're offering their affirmative defense, their version of the story. They're saying, actually, plaintiff, you sought us out. You arranged a meeting with us. You wanted the interview. And when you did come for the interview, you explained that you wanted to work with us specifically. You wanted to leave your practice and work in-house for this company. We told you that there would be peaks and valleys to the workload, but that we would try to keep you as busy as we could with large volumes of work. But again, there are peaks and valleys during the year, and we couldn't make any promises. We'd said we'd accommodate you as best as we could, but you needed to be able to meet the deadlines or make up for the time lost. And you assured us that you would make it happen. You assured us that you promised that you would do all these things for us. Us, on the other hand, we didn't make any hard promises. We didn't negotiate on a salary. We didn't even negotiate on vacation at this point. So another story is coming to light now. This is the defendant's version of events. We saw in the statement of claim kind of half of the story, and now the other side is unfolding. So you promised us all these things. When we were hiring you, you made yourself out to be this great accountant. And then when we did hire you, that wasn't the case, right? The first few months were quieter selling weeks. You know, it was Christmas holidays, people had purchased all their stuff already. And given the slower pace, we wanted you to maybe take time to mentor the junior accountants. So it's not that you weren't in a position of seniority, you always were in a position of seniority. We just asked you to do something else just to kind of help out and keep you busy during this time. And as we discussed, your salary was supposed to be increasing in time. You had a base salary and then you get bonuses. So they're not only denying everything the plaintiff said, but they're actually giving their own account of what they believe was said in these conversations. And they're saying, listen, you made yourself out to be this great thing. We offered you what we think was reasonable. And when it came up to it during tax season, the busiest season, you really, 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 really didn't do what you were supposed to. You asked for this time off, right? You requested 4 or 5 days off a month, and we granted it to you in early January. You asked for the time off, and we gave it to you. But then, midway through February, you had taken 13 days off. And many of these days were notices the evening prior or the morning of. And, you know, you left us scrambling. After the 8th absence, we had somebody discuss with you, and we warned you that we required more notice, and yet you still kept doing it. We never suggested you faked it. Actually, when you complained about discrimination, we actually followed up with an internal investigation because that's how seriously we took your claim. So now we're really seeing the other side of the story unfold. First, you think, man, this plaintiff's really been dragged through the mud. And then you get to the statement of defense and you think, oh wait, maybe there's something more here that wasn't said before. Remember, there's always two sides to every story, and now the defendant is getting their chance to tell their side. And this is what you want your pleadings to do. You want them to lay out your facts in a compelling way. Okay, so these are the 4 typical things in a statement of defense. And if we review the timeline so far for the claim, it starts with a plaintiff who decides to sue. He files a statement of claim, and then the defendant gets to file a statement of defense, which will deny what they don't agree with and put forth their version of events. Now, what if the defendant doesn't file a statement of defense? What if they just don't meet the deadline, they forget? Who knows? What if it's just not there? Something called a default judgment would happen, and you see it in the boilerplate language in the statement of claim. Remember, you don't need to know all this. This will be found on the Ontario Court Forms website, and it's going to be placed at every statement of claim at the beginning of every statement of claim. So it says here, if you fail to defend this proceeding, if you don't deliver a statement of defense, judgment may be given against you in your absence and without further notice to you. So if you don't file a statement of defense, you might lose the case overall without having a chance to say your piece. Now, many plaintiffs would assume that if you file a statement of claim and the defendant doesn't do anything, you can proceed immediately to enforcement and garnish their money from their accounts, but that's not necessarily true. There's a little bit of a process after this default judgment occurs, but we're going to get into this in a later video. All right, so in the timeline, we have a statement of claim and then a statement of defense or a default judgment. And the third thing that can happen is that the defendant can attack the pleading. If the pleading is so deficient, so scandalous, it has absolutely no backing, the defendant can forego drafting a statement of defense in response, and they can actually bring a motion and request the court and tell the court, look, this statement of claim is so bad, you should just ignore it completely and drop this case. So that's another thing that defendants can do in response to a statement of claim. They can file a statement of defense. They can do nothing, which likely will entail a default judgment against them, or they can attack a pleading for being so deficient and telling the judge, listen, just let me win or drop this case because this is really not worth your time. All right, so we've seen what we should do in drafting a pleading. And that finally brings us to the last case, which is Jacobson and Skurka. And this really outlines what not to do. So Jacobson was a sort of entrepreneur guy who ran this online pharmacy, and he was charged by the US government for illegally selling drugs. And Stephen Skurka was Jacobson's defense lawyer in this American criminal proceeding. So the case didn't go well, and Jacobson sued Skurka afterwards for doing a lousy job representing him. So he's claiming there was negligent representation. Jacobson issues this long, provocative statement of claim, and Skurka replies with an equally long, provocative statement of defense. So the judge goes through all these pleadings and all the things they pled inside of them and really outlines all the things that were inappropriate for pleadings. There's a lot in there. Highly recommend reading it if you want to have more insight into it. We won't go through it all here, but let's draw out some critical things that the judge said don't belong in a pleading. So as we already know, material facts have to be included in a pleading, but evidence isn't to be included. And the rules are clear about that, but the boundary between them is sometimes blurry. So it all comes down to detail. Material facts tend to be more general statements and summaries of what happened, whereas evidence tend to be more granular. They tend to want to prove the truth of a statement. Some things are dead giveaways of evidence. For example, if you are citing specific documents, recordings, direct quotes. But as this case shows, even facts, which are just too granular, too specific, can fall on the wrong side of this divide. So you don't want quotations to be in there. Those are going to be struck out. And even a pleading of an admission, saying that on a particular day they did something, that can be evidence. Saying things like employee X's billable hours were too low is a fact, but then saying on the other hand that on March 2, 2002, he only billed 13 hours is too specific, it's too evidentiary. Quite a fine line, but it has to be a balance. This case also says legal reasoning and law doesn't belong there. There should not be a discussion section in the pleading. It's not a place to do that, and there also shouldn't be too many irrelevant facts or details. So lots of the things will be facts, but the court doesn't really want to see everything that isn't material. So while it may be a fact, for example, that the plaintiff had his own office desk, it doesn't really advance the discrimination piece, and it doesn't really speak to the dismissal case. So we don't really want to waste anybody's time in putting it into a document and then having the other side acknowledge it. The judge also comes down on them for useless padding at paragraph 59. They're saying avoid ad hominem arguments and avoid personally attacking each other. This is not a place to really attack someone's character. It's not appropriate. Attacking competence in professional terms is okay if you're trying to say somebody wasn't up to par, but you don't want to start attacking them on a personal level. The language has to be restrained. Another thing is Skurka, the defendant lawyer, said, I got this guy a very good plea agreement. The court finds that to be congratulatory and self-serving is not the right thing to do in a statement of defense or in a statement of claim. You want to tell the story, but you want to tell it in a way that shows your dispute through the eyes of either party in a factual way without resorting to the type of language that these guys were getting into. All right, so that's pretty much everything for today. Stay tuned for more videos on civil procedure and civil litigation. And as always, thanks for watching.